Hello everyone, Andrew Bethel with the Bethel Law Corporation, and as you are probably aware, we are an estate planning law firm located in Redlands, California. With us being an estate planning firm, that means two of our biggest practice areas are assisting our clients with navigating probate court and helping them avoid having their estate needing to go through probate court in the first place. So today I wanted to discuss a brief overview of just what is probate and what causes an estate to have to go through probate in the first place. Now, probate itself is a very old court system, and because of that, there are a lot of nuances and details that do need to be discussed, but this video is more of a broad overview of the probate process in general, and we'll do some specific deep dives later on. As we go through each process, you might have a couple questions or anything like that. If they do crop up, you can go ahead and just call our office and just ask the questions. We won't charge you for a phone call or consultation or anything. And again, we'll do some deep dive videos into some more specific topics in probate in general at a later date. But today, here's a brief overview of probate in California. So first of all, just what is probate? Well, probate is the court system where an estate needs to pass through in order to go on to the next generation. Probate is that legal process of passing one's estate on to their heirs and beneficiaries. Now, there are two triggers that cause an estate to have to go through probate here in California. Again, it'll be a little bit different depending on which state you're located in, and some of these might change over time, but just kind of know that there are two triggers, one of which is the gross value of your estate, and the other is real property. So the gross value of your estate must be under $166,250 in order to avoid probate. An estate over that amount does have to go through probate. If there's something below that number, there are expedited processes that can be used in lieu of having to go through probate. Now that number includes everything. It's cumulative. So your checking account, your savings account, your cars in the garage, it grabs all that stuff, puts it all together, and if that number is $166,250 or more, then a probate is required. If it's under that amount, then no probate, we can do a shortened process. The other trigger I mentioned is real estate. In California, real estate prices are pretty higher than a lot of other states in the nation. So a general rule of thumb, if you have real property in your name as an individual and you pass away, it's pretty much a guarantee that your estate then has to pass through probate in order to be passed on to the next generation. And the reason we have probate court in general is kind of think about it. You have assets. You have the ability to gift those assets or sell them, but typically they might involve a title. For instance, your home has your name on title. But if you pass away, you're no longer there in order to sign clean title in order to pass it on to somebody. So since you have passed away, we need a judge's order to say that, yes, this property was in this person's estate, and it is now clear to be passed on to the beneficiaries, or usually your children. So in the probate process, there is a kind of general process we need to follow. I'll go over the steps in particular later on, but in general, to start off, your assets will be collected and identified. Any outstanding debts or creditor claims will be paid and satisfied, and a final tax return on your estate will be paid. And with that, your assets will be distributed down to your beneficiaries. Now, note, as I said, this is a court process, so that does mean there is court oversight over everything that gets done. But the person actually doing the grunt work is going to be the manager of your estate. They might be called the executor or the administrator. We'll go into those terms in just a moment, but just know that whoever that person is, they are the manager of your estate. So they're going to be the one going out and doing the grunt work, closing down accounts, signing off on paperwork, and distributing the estate to the beneficiaries. But again, all this process will be oversaw by the probate court. Now, before we get into the step-by-step of what to expect in a typical probate proceeding, There are a couple terms you should probably be aware of because they are pretty old and antiquated, some of them, and they are terms and phrases you'll see throughout a probate process if you are involved in one in California. So the first terms you'll likely see first is estate. That is all of the property that the person who passed away, everything that they own, and that person who passed away, they're known as the decedent. Thus, everything they own is the decedent's estate. Additionally, you might come across the term intestate. That just means somebody passed away and they did not have a will. So if that happens, the distribution of their estate goes under what is called intestate succession. Additionally, you might see the term issue. Just know that that means children. Next, we have executor and administrator. And I mentioned these two terms previously, and they do fill the same role, as in they identify the manager of one's estate, but they are differentiated based on whether or not the decedent had a will or not. If the decedent had a will, the person in their will who they nominate to be the manager of their estate is the executor. If the person did not have a will, then the person who the court appoints as the manager of that estate, they're called the administrator. Now, the court form that lays out and nominates, identifies who's going to operate in that manager role is what is called the letters. If somebody is operating as the executor, they get a document that is known as the letters of testamentary. If the person is operating as the administrator, they get what is called the letters of administration. Finally, the two terms you'll come across are beneficiary and heir. Now, in common parlance, these terms are used interchangeably, but just kind of keep this general rule in mind. If somebody is a beneficiary, usually means that they are somebody named in a will as somebody who is set to receive an inheritance. If somebody is an heir, that usually means that they are somebody who is entitled to an inheritance, typically under the laws of intestate succession. This is usually the children of the decedent, so the decedent's issue. One thing to also keep in mind, you can have a contingent beneficiary. That just means that they are somebody who isn't set to receive an inheritance unless some condition happens, usually if somebody else passes away in the meantime. So for instance, a grandchild might be a contingent beneficiary and will only become an actual beneficiary if their parent passes away because their parent is named as the beneficiary. Next, I wanted to discuss the steps that one would see in a typical probate action here in California. Again, this is for a typical case. Everybody's individual probate case is a little bit different, and there will be different considerations or facts that do need to be navigated around and might adjust what we discussed today. But this is intended to just provide a general overview of what to expect. So first is production. When the person passes away, the decedent, if they have a will, that will needs to be produced to the executor nominated under their will and the court that can exercise jurisdiction over their estate. So the executor is the person under that will who the decedent has picked to be the manager. Now that original will has to be logged with the court that can exercise jurisdiction. Now determining that court, pretty simple process. It's typically the county in which the decedent passed away in. It can also be the county in which the decedent owned property if it ends up being different than the county they passed away in. So, for example, if somebody passed away in San Bernardino County, but their house was located in Riverside County, then either San Bernardino or Riverside County can exercise jurisdiction over that estate. And again, the executor is the one nominated under that, so the executor is the one that should be logging that will with the court. Now, logging that will is the next step, petition, because that executor is going to be filing a petition to be appointed the executor. Just because they're nominated under the will doesn't mean they automatically get those powers and does not mean they automatically are the executor with authority. They have to get permission from the court. Now, there are different petitions that can be filed, but it usually comes down to, if there is a will, we're going to do a petition to appoint an executor. If there is no will, we'll be doing a petition to appoint an administrator. If there is a problem with the will to where a part of the will or the entire will might be rendered void, then we are going to file a special petition in that case regarding what if the will had a problem and the court needs to make a determination as to the validation of that will before the probate can really get underway. So that's production, petition. Next, we have notice. And notice means that everyone who might have an interest in the estate does need to be notified of those probate proceedings. So those with an interest are typically children, the issue of the decedent. Additionally, a public notice does need to get printed and sent out in a local public newspaper to provide a public notice that somebody has passed away. Now, this provides kind of two steps that do need to be taken. It provides notice to anyone out there in the community that might have an interest, whether they be a relative that maybe wasn't included for whatever reason with the notice the executor or petitioner at this point provides. And it also provides notice to potential creditors in the area to file a claim on the estate. So following the notice period, we have the appointment time. At that point, we have a hearing in front of the judge, and the judge appoints who's going to either be the executor or the administrator. At that point is when that person can then operate as executor or administrator, as the manager. After that point is the next step, consolidation or marshaling of the assets. With those letters given by that judge, the manager can now go out and start collecting the assets of the estate, which typically involves closing down bank accounts, liquidating assets, maybe having a garage sale for personal items, selling off vehicles, or if a house is involved, selling a house. Now, all those funds are to go into what is called a blocked account or an estate account, where they're going to remain in there. And during that consolidation period, the executor or administrator is also going to be paying final bills and expenses that the estate might owe, which is also when creditor claims are going to be satisfied. Now, at this time period, the estate is required to be open for at least 4 months. And that leaves at least 4 months for creditors to crawl out of the woodwork and make a claim on the estate. After that time period, if the probate action is wrapped up, then those creditors are out of luck at that point. They can no longer make a claim on the estate. They are precluded from doing so by law. That's why we have that 4-month waiting period. Now, in reality, that 4 months isn't going to be 4 months on the dot. Because of reasons we'll discuss in a moment here, that timeline is often going to stretch out to closer to 6 to 9 months for that period there. But just know that at least 4 months is when the estate has to be opened. Finally, once all the assets are consolidated and marshaled and in the estate account or accounted for, the executor or administrator has to provide what's called a final accounting to the court. That accounting shows all of the assets of the estate. It applies values to different things, shows what's been liquidated, and is supposed to show how the money in the estate account essentially got there. And upon the court's approval of that accounting, the court then orders fees to be paid. For instance, attorney fees get paid at this point. The executor or administrator gets their fees. Any outstanding debts get paid at this point. And upon approval, the final checks, essentially, to the beneficiaries get cut and distributed out. Finally, to wrap everything up together and provide a little additional context, the probate court action in California is the process of passing one's estate on to the next generation. And again, There's two triggers for how we end up in a probate court. First is assets that altogether or cumulatively are worth more than $166,250. The other trigger is real estate, real property, land. Next, as I mentioned, you're typically going to go through all those steps I outlined above, but there are a couple other things you do need to be aware of with a probate action in California. Firstly, not every single asset is required to go through probate. Some assets can avoid probate, but again, as I mentioned, those are particular topics that we can discuss in later videos. But just kind of know off the top of your head, if you have assets that are in a trust, then the trust can distribute those to the beneficiaries without having to go through probate court. Or if you have assets with pay on death designations on them or beneficiaries on them, or sometimes if you hold assets jointly with other people. Now, another thing to keep in mind, and I kind of alluded to this before in the steps seen in probate, is the timeline. Probate courts in California are pretty busy when compared to other states in the United States. In California, we can typically expect the normal probate, that is a probate without any strange surprises or without any challenges. We can typically expect those to last anywhere between 9 to 12 months. Now that is 9 to 12 months where no beneficiaries are receiving their inheritance, and until the executor or administrator is appointed, the family is having to pay any fees or expenses that pop up to that point out of pocket. Now they can get reimbursed at the end, but just know that they will have to provide a little bit of an upfront cost in order to get things moving. Typically, there's also court fees, filing fees, notice of publication of death fees, closing fees for the matter, and what's called probate referee fees, people who assess the value of different assets in the estate. And with those all together, of course, it's going to be different for each estate, but you can expect something within the ballpark of around $1,500. Finally, there's the time. As I kind of mentioned before, a probate does need to be open for at least 4 months following the appointment of the executor or administrator, but we're dealing with court timelines here, which means we have to get hearing dates on the court's calendar. And as I mentioned, probate courts in California are pretty busy. That is what leads us to the typical probate court action taking about 9 to 12 months. And of course, this will vary by jurisdiction. LA court, very busy. You go to a smaller county, they're going to have more availability on their court calendars, and it also might depend a little bit on where in that county. So for example, Riverside County, you can go to downtown Riverside for your probate hearings, but there is also a probate court in Palm Springs. And sometimes it's even down to which individual court you're in that might determine the timeline you can expect. So with all that, that is intended as a brief overview of probate in general. As I mentioned, there's a lot of topics in there that we can go in deep dives on their own, but I just wanted to provide what to kind of expect under a typical probate here in California. Thank you for watching our video. Be sure to like and subscribe to stay up to date on everything estate planning. You can also check out our Facebook, or if you're in California and want to schedule a free consultation or just read a little bit more, you can check out our website, bethellaw.com.